The Saskatchewan government has lost its constitutional appeal of Justin Trudeau's carbon tax. The Court of Appeal for Saskatchewan ruled in a 3-2 decision that no part nor the totality of the federal carbon tax law, the Greenhouse Gas Pollution Pricing Act, is in violation of the Constitution. Now, what was interesting about this decision is that 2 judges found that the entirety of the act is in fact in violation of the Constitution. And despite the element of this that only one vote was ultimately the swing between this legislation being found unconstitutional versus it being found constitutional, the federal government has been absolutely jubilant, saying that this somehow vindicates its position that it has not only a right, but some half-baked moral obligation to impose a job-killing carbon tax on Canadians. Take a look at the statement that Environment Minister Catherine McKenna put out. She heralded this as some sort of victory against climate change denial and a victory against the Conservatives, and gave this ultimatum to Conservative premiers. Look, I obviously wanted the court to rule the opposite way. I wanted it to find that, in fact, the Saskatchewan government's approach was the correct one. But as I noted when I covered at Osgoode Hall the Ontario government's challenge of the Greenhouse Gas Pollution Pricing Act, that this is going to be a long road before we get a final answer. There still is no decision on Ontario's court reference case. The new Alberta government under Premier Jason Kenney has vowed to fight this in court as well. We know that New Brunswick is waiting to see what happens with the other provinces before pushing for anything on its own. And ultimately, because there will be at least 3 different provinces' constitutional questions assessed by provincial courts, the Supreme Court of Canada will ultimately get the final say on this. And that's going to be the one people should be waiting for before claiming any sort of ultimate victory here, as Catherine McKenna has done. Now, the key in this decision, as I've read through it, is, well, first off, the court has dismissed the alarmist rhetoric we were hearing from the David Suzuki Foundation and from the Intergenerational Climate Coalition. The court basically found that there's no argument that this is a national emergency and that that should authorize the federal government to behave in this way. What the court did find is that this is a regulatory charge, not a tax. That means that the court agreed with what the federal government said, that revenue collection was not the primary purpose of this. But there was a line in this that stood out to me as a little bit odd. The court said that the reason it thinks this is not a revenue gathering tool is because provinces have the option to gather the revenue themselves, which means the federal government wouldn't have to gather it. Well, if you're a taxpayer, I don't think you care about which hand is reaching in your pocket as much as you care about the fact that a hand has to be reaching into your pocket. So that's going to be an interesting dynamic as we look at the case moving forward in Ontario and ultimately the case in Alberta. Another aspect is that they found greenhouse gas emissions are narrow enough in focus that the government could designate them an issue of national concern. And where Canadians need to be very on guard about this is where the Ontario and Saskatchewan governments put forward their primary concerns. That if the federal government can regulate greenhouse gas emissions because of climate change, then that means they'll be able to regulate everything that causes greenhouse gas emissions, from your wood stove to the car that you drive to your home heating temperature. The court said this was a little bit of an exaggeration, that this wasn't something that would happen because the federal government will have to limit the scope of future legislation. But the whole point here is that the federal government has now been given the green light, at least for the time being, to put forward broad sweeping laws, even if they may trample on provincial jurisdiction. So while it is the loss of a battle, it's not the loss of a war, and we'll continue fighting on this for taxpayers. For True North, I'm Andrew Lawton.